Assalamualaikum and hi everyone. We will discuss about the challenges faced by the court in Malaysia when deciding a case under the subtopic of jurisdiction.
To start off with, let's talk about jurisdiction. Jurisdiction may be defined as the authority of a court to make judgments. Malaysian courts determine a case's most suitable jurisdiction by looking through Section 23 and 24 of the Courts of Judicature Act 1964, as well as common law principles. Jurisdiction is important to the parties as different laws in different countries may provide for a different outcome in a suit.
What are the challenges faced by the court under this subtopic of jurisdiction? So there are 5 challenges which we will discuss in this video. Firstly, identification of appropriate forum. Forum convener refers to an appropriate forum to determine the dispute. The court had an inherent jurisdiction to stay an action in Malaysia or to restrain by injunction the continuance of proceeding abroad in circumstances where it was necessary to do so and to prevent injustice. In seeking to decide whether there is another forum which is clearly more appropriate, the court will seek to identify the natural forum as being that which the action has the most real and substantial connection. The second challenge is where witnesses, parties, are evident at different places. Where both parties to a contract are Malaysian residents with all of their assets in the jurisdiction, the negative repercussions of such an omission are typically negligible. Court filing expenses are rather low, and a solid matter may always be made the subject of a summary and injunctive relief application. Since it requires very little ingenuity to mount an arguable defense, years may go by before the trial. Besides, with mutual agreement, arbitration can be resorted to even after a dispute has arisen. However, when one party to a contract or its assets are situated in another jurisdiction, significantly different issues arise, which may need arbitration. The third challenge is where the court have to identify whether to follow the approach in the case of famine or the elephteria. So the challenges here is that the court have to identify which approach is more appropriate to follow.
The next challenge is the identification to place of business. The registrations of business is not compulsory as long as the business is being conducted, as cited in the case of South Indian Shipping Corporations. However, there must be shown a permanent location associated with company for an overseas company to fall within the term place of business. Therefore, the court have to decide whether the business conducted fall within the classification. Last challenges is the injunction to restrain party from abroad legal proceeding. It is well recognized that injunction may be granted on the ground that foreign legal proceeding constitute unconscionable conduct. Unconscionable conduct can only be determined through the examinations of the facts of the case. Also, the English court must proceed with caution before granting an anti-suit injunction. Thus, the challenges is whether to grant or not to grant an injunction.
Where issues are faced concerning the conflict of laws, some solutions are provided. We will provide 3 solutions to the challenges previously mentioned. The first solution to be discussed is Order 11 from the Rules of Court 2012. In the event that the defendant of a case is not in Malaysia, Order 11 may be used, provided that the situation in question falls under one of the 14 provided by the statute. The principles in order to use Order 11 were established and discussed by the case of the Hagen, 1908. The first of these is that the plaintiff must have a good, arguable case. The rules go on to impress upon the court the importance of caution when serving a writ to a foreigner outside of Malaysia and the full and fair disclosure of all relevant facts. It goes on to further direct the resolution of any doubts or ambiguities of the rule in the favour of the defendant. The second solution offered is that of an anti-suit injunction. May attempt to stay the action taking place in another jurisdiction because Malaysia has been determined to be the best forum to hear the case. The court does this by placing an injunction on the plaintiff, which effectively forces him to stop his actions abroad. As discussed in the case of BSNC Leasing and Sabah Shipyard in 2000, the decision of how proceedings would conclude if carried out in a foreign court is heavily dependent on the facts of the case. However, the case does not provide a standard to guide decision-making. The third solution is the Reciprocal Enforcement of Judgments Act 1958. Here we must consider the solution presented by the Reciprocal Enforcement of Judgments Act 1958. This is the statutory method of enforcement where a case is heard in a foreign court and the judgment is wanted to be enforced in Malaysia. This act applies to countries that agree to enforce Malaysian judgments. These are the UK, Hong Kong, Singapore, New Zealand, India, Brunei, and Sri Lanka. These judgments can only apply to civil cases and must be conclusively determined.
Every problem has its solution, and while the courts may face some difficulties in determining a case's jurisdiction, there are ways for these difficulties to be resolved, as we have explained throughout the video. It is important to resolve these issues, as being heard by courts of the right jurisdiction would ensure justice to be served for both contesting parties. With that, we conclude our presentation. Thank you.